I have wonderful panelists with me who are going to help us navigate this interesting topic. I have Mr. Amar Kumar Sundaram, who's a GC, Senior Vice President Legal at NEC. He's also Chief Compliance Officer. We have Mr. Vineet Vij, who's joining us very graciously. He's agreed to be part of this panel also. Thank you, sir. He's GC at Tech Mahindra. And we have Justice Kevin Zarvos, Justice of Appeal, Court of Appeal from the High Court of Hong Kong. Thank you so much, sir, for joining us today. So we have an interesting panel and we have an interesting topic. We've just finished a topic on white-collar crimes. We are not going to talk about white-collar crimes. I can sort of at the outset say that. So don't worry, it's not going to be an overlap of what was discussed earlier. We're going to talk about how to handle investigations. Okay, I'm going to keep this session short. We have, I think, by 1:45 or so, we may break. We'll have a half an hour session in the interest of time, in the interest of, so that we don't overrun the schedule. I hope that's fine with the other panelists as well, right? So today in India, we are seeing a spate of investigations. We are seeing different regulatory bodies, different investigation authorities, governmental authorities issuing a lot of summons. There are a lot of investigations, there are dawn raids, a lot of things that are happening in order to gather information, in order to make out a case, in order to see if there are any non-compliances that have been, that have occurred at the companies, etc. Now, we are going to divide this session and talk about both internal as well as external investigations. Okay, we have two general counsels here who are going to give us an inside view of how they handle investigations internally, what are good practices, what are best practices, etc. We have Justice Zarvos, who's also been the head of the prosecution in the past in dealing with ICAC cases in Hong Kong. And he's now a judge dealing with similar cases. So we're going to ask him for his insights, both as, we are going to ask you to wear your prosecutor hat for some time.
You don't have to give a judgment.
No, as long as you don't have to give a judgment. The only thing, it'll be binding or not, we'll figure out. But yes, so we're going to talk about all that. So today, as I said, we have a spate of investigations. I think a lot of us who are dealing either as litigating lawyers or as in-house counsels or as corporate lawyers, some point or the other, very regularly are getting asked by our clients to help them with internal investigations, help them with investigations in dealing with informational exchange within the organization. I know that we get a lot of queries on, is this okay? Can I send this information? Can I give this information? What is going to be the implication in some other law? Can there be exchange of information between investigating bodies? How do you handle internal investigations? What triggers internal investigations? And what is the practice in India with respect to internal investigations? So that's broadly what we're going to cover. As I said, I'm going to ask Justice Zarvos to come in to discuss aspects of evidence, aspects of best practices, what kind of advice, from a prosecution side, what has he seen, what are some of the mistakes that perhaps companies can avoid. So I'm going to jump straight to Amar. I'm going to ask you, okay? So let us start with a summon being issued to the company, okay? First of all, how do you ensure, what systems do you have in place to ensure that that comes to you first? Because a lot of times we see that it doesn't even come, it will go to the reception, I'm guessing, and then by the time it makes its way to the legal team. So, right from there, you need to have systems in place. So I'm going to ask you, from inception, from get-go, the summon has come to your office, what do you do?
Thank you, Charanya. Very relevant question, in fact. And most of the organizations have this policy, and if they don't, they should. That the moment there is a communication coming from a regulator, and regulator would also include the investigators, be it SFIO, be it CBI, be it ED, be it police, be it EOW, legal should always be involved. And therefore, the timing of these notice and the time to respond and analyze what the issues are is very, very critical. So, there has to be a policy which should clearly mandate that the moment any communication comes from a regulator, immediately the legal should be.
Right.
Now there can't be a compromise on that position.
Right.
Now the second important part is that the moment a notice or a summon comes, there is all of a sudden there is a panic, right? And business people will get panicked that what will happen now. So the first thing that as in-house counsels and as general counsels, what we need to do is that make them calm, don't panic. I have seen organizations where people in whose name those summons comes up, they quickly start deleting some of the emails.
Right.
That's the first thing, that out of panic. And therefore, another good practice that we all do, and which is very advisable, is that a document preservation notice should be given, whereby all those people who are involved in that particular project, which is a subject matter of investigation, they should desist from deleting any emails or any records that is there. Because in today's world, anything that you delete is not only can easily be retrieved, but it goes against you.
Yes.
So the document preservation notice is very, very important. The second important aspect as in-house lawyers is that examine that summon and try to understand what is the issue behind that summon. Not everything will be explained in that summon or a notice that you get, but try to figure out what is that it is all about, and therefore try to find out that where possibly the organization could be asked and what kind of questions will be asked. Many a times these summons are issued to organizations maybe as a witness, not necessarily as an accused, and your role completely changes when you are attending those summons as a witness or as an accused. That's changes the complete role. And therefore try, and all these are something which is in the domain of an in-house lawyers. So that's the role. Third is you should extend full cooperation to the investigative agencies. As a good corporate practice, whenever these summons are issued to us, to the organizations, they should extend full cooperations. There are many instances where you can't immediately respond to a summon. You need time to investigate and find those documents, ask for an extension. And I have seen in my experience that regulators agree to your extension. It's not that they push that these information are needed tomorrow itself. They understand. So these are the basic hygiene conditions that we should all look into. Touching upon that very controversial issues on the privilege space. In India, unfortunately, in-house counsels doesn't have that benefit of client attorney privileges, unlike Singapore, unlike US, and unlike UK, where there is a client attorney privilege. In India, this privilege is not there. So whatever is communicated between general counsel and the business team are not subject matter of privilege under the Indian Evidence Act. So that's a challenge. There are news item where even the lawyers were raided. Recently, we all saw in the newspaper some of the big names in the law firms, they were raided, even though there was an attorney-client privilege. So the powers of the regulators and investigators are pretty wide under CRPC.
Yes.
And we should be aware of that.
Thank you. Thank you, Amar. I'm now going to want an intervention both by Mr. Vij as well as Justice Zervos on, let's look at privilege, right? And if I can understand the scope of privilege, as Amar rightly said, there is no privilege when it comes to attorney-client privilege for an in-house counsel, okay? So I want Mr. Vij to perhaps come in and say, what do you do? How do you get over this, right? How do you deal with it, number one? Because what is the expectation of business from a GC when it comes to this kind of informational exchange, especially in the heat of an investigation that's going on? And then I would maybe want Justice Zervos to tell us, the impact of this maybe while doing, dealing with prosecution or prosecuting matters when he was in Hong Kong. What is the difference of, having privilege? How much power do the internal counsels have? So I'd probably ask Mr. Vich to go in first.
So thank you, Sharanya. But I'm just adding to what Amar said, particularly around, the summon received and there is a subject and you're not sure whether you largely know you are a witness, oblique, an accused, but there is a panic already in the organization.
Right.
And maybe just to add also, a lot of times listed, unlisted companies will have a registered office where hundreds of companies will kind of have their offices. So I think need to build an automated system so that it reaches the legal department first.
Right.
Secondly, I think, especially with the global experience, you realize that discovery is an important process when it comes to US, UK, etc. I mean, in some way or the other. So the important question is, how do you tell the concerned business guys that, look, there is an issue, take it seriously, or else you have a problem on hand.
Right.
I think that conversation is important. You need to tell them it could be a litigation hold notice, or you could name it by whatever name. But the GC really needs to, or the legal department really needs to play a role there in terms of the moment you receive a notice, litigation, etc., you tell them, just put everything on hold. The document is not to be erased and so on and so forth. So coming back to your question now in terms of privilege, etc., yes, we don't enjoy that privilege in India for sure. And so therefore we take the obvious route, which is getting a law firm into the position. So anything that I want to do, I get it done through an external law firm. So for example, if there is a investigation to happen, we'll let a law firm handle it. I mean, that's what we are doing it. I mean, EVPs Big Fours or which will not have the privilege though, but you get a law firm and then make them write to you. We a lot of times take even a draft opinion also, especially I'm talking of the US and UK particularly, and you let the law firms and therefore you enjoy that privilege.
Right.
That's something that we use very often and we use it effectively.
Right.
That's the only thing which works, unfortunately, at this point in time. But Amar is also part of that movement in terms of getting some kind of a privilege for Indian in-house particularly. And Mr. Prasanna is here. I need to add, you have the foreign law firms who are allowed to now practice with whatever restrictions, etc., but you still don't have the in-house counsels to be even called the advocates. So that's irony to my mind. And what to talk of privilege. So you have to resort to external law firms, actually.
Yes. Justice Zervos, if we can get your inputs on privilege.
Well, my view is one as a former prosecutor. And I was a federal prosecutor in Australia and then continued that work in Hong Kong, mainly doing white-collar crime, anti-corruption, anti-money laundering. And so I had a lot to do with dealing with investigatory agencies, especially when they're dealing with corporations. And the role of an in-house counsel is a very difficult one in those situations because generally an in-house counsel will not have the particular expertise to be able to deal with a criminal investigation or a regulatory investigation. They may have general knowledge and there to assist the corporation generally, but not specifically in relation to a particular issue that may emerge for the first time. So the first thing that I would stress is as an in-house counsel or within a corporation, you've got to know what you're doing. You don't go into a situation blind. So if you're dealing with a regulatory agency or a criminal law enforcement agency, you need to know the powers, the functions, and if they've served a notice on you, you go to the source material. I say this time and again, and how many times I see lawyers have not done this, where they don't go to the actual specific statutory provisions, the relevant regulation, or even the case law to know what the ambit and scope of the particular notice, what their obligations are, what protections they may have, what rights and privileges, etc., are available to them. So that's why you really do need to know what you're doing. And if you don't know what you're doing, don't do anything. Go to somebody that knows. Now, in relation to the specific issue with legal professional privilege, when I was involved in cases where I would deal with the law enforcement agency, I would settle search warrants or notices, and there would be a degree of tension between us sometimes. So don't think it's all one way. A law enforcement agency can just go and do what they like, because they're subject to the accountability of a prosecutor like myself that wants to make sure that we're complying with the law and we're doing things to a requisite standard. And that's why it's useful also to go to the guidelines or the scriptures that may be available in relation to the specific law enforcement agency or the prosecution guidelines as to how things should be done, and ensure that they are being done according to that standard. So, for instance, in Hong Kong, we have a prosecution code, and that is a public document that allows anybody to have access to it, to see on what basis the prosecution or a law enforcement agency is exercising a particular power. And so it's not only something that the prosecutors abide by, but it's also a means by which they are accountable to the public. So I think a lot is overlooked in terms of internal documentation or public records that you can go to see what should be done and how it should be carried out properly. Now, LPP has come up a lot of times in Hong Kong. When I would authorise the law enforcement agency to issue a search warrant, and I would see that there's a possibility of seizing legal professional privilege material, I would have it endorsed on the warrant, so that when the issuing magistrate granted that warrant, that it would be seized and sealed material that was subject to legal professional privilege, so the law enforcement officers could not look at it, and it would be subject to a period of time of 14 days in which the aggrieved party would seek some form of redress, either by taking court action, collateral action, and asserting their claim of privilege. Now remember, LPP belongs to the client. So the lawyer, let's say you've executed a search warrant on a solicitor's firm, it's not their privilege, it's the client's privilege, but they must assert that privilege on their behalf. They must at least protect it so that the client can then claim it if they want to. And then the process. Now, what we do in Hong Kong is sometimes when material has been seized, and it is contentious as to whether it's covered by LPP, and so as not to allow the law enforcement agency to look at it, is we appoint an independent body or a council to come and examine it to determine whether it is covered by LPP or not.
That's good to know. So even in India, I mean, we've looked at client attorney privilege in some instances, and again, as rightly said, it is the privilege of the client, not of the lawyer. And here also, even with an external counsel, the client can waive the privilege if they so want during any enforcement or any investigation that's going on. But now let's move to two more aspects that I want to touch upon. One is in the backdrop of so many investigations going on, in the backdrop of companies becoming so global that they have, for example, Tech Mahindra, you have employees across the globe, right? How do you build a compliance program? How do you build a culture of compliance in your organization? Number one, okay. And what kind of checklists do you have? What kind of trainings do you do? So that's something that I want you to sort of talk about.
So, Sharanya, just going a little back, I can go back to times of 2000, 2005, when IT companies particularly went global and, they were growing business left, right, and center. Compliance was not on the top of their mind. Possibly the idea was to, meet the top lines, etc. And then you had this Lehman Brothers and all of that world falling, financial crisis. That's probably the time you realized. And of course, if you have to do business globally, you need to be, having some compliance framework. So both of them put together is when these Indian organizations realized it's high time to get compliant. And there is when most of the companies invested into a compliance structure. I mean, my past employments have been with IT companies and in multi jurisdictions. So, I mean, if I was to go back, what did we do really? We didn't spend much on external agencies, and there are hardly any external agencies who can help you get you a global solution. Maybe now, yes, but maybe not, then not. And so what did we do was, let's deep dive into our org structure at that point in time and see how does compliance work in that region, jurisdiction, etc. So you had the big four checklists, you had the lawyer's checklist, you had the employment law checklists, and all of that. So how do you put that together? And that's something that we did as in my last organization. We brought all of that together in Excel sheets to automated modes or whatever. And that was the starting point. And then we went through a validation process. So then you validate or revalidate, basically. So that was the step number 2. And possibly there was a tool ready then to see how the companies will operate in the local jurisdiction. So it could be a branch, it could be a legal entity, whatever structure. So you basically divide between the corporate laws, the tax laws, the administration laws, and new categories of laws which got added from time to time. So I think that's how you build a structure, a whole ecosystem actually, and then get this going. And then I think in the last couple of years, we've seen, as you rightly pointed out, the laws come into place, more regulatory interferences, etc. So I think all companies now need to be, adopting systems, and I think there are enough systems in place currently. So.
Thank you. Yes, please. Yes.
What Vineet said, compliance, all of a sudden in last 10 to 15 years, and because of a lot of actions by the regulatory agencies, the focus on compliance has increased. And now organizations are very focused on comprehensive compliance programs. And I always say that if you want to understand the importance of compliance, be non-compliant and then you understand. So now 250 crores is the minimum. I mean, that's the amount which will trouble you now if you're not compliant with the data privacy. So be non-compliant and you will understand the importance of compliance. But having said that, one of the major checklists for a good compliance program is keep reviewing your compliance policies on a very, very consistent basis. And in the last panel, this issue came up and I wanted to touch upon it. There are a lot of discussions which is happening around the encrypted messages, right? And it was touched upon in the last panel discussion. I just wanted to elaborate on that and why it is important. So Department of Justice in US in March 2023, they revised their complete evaluation of corporate compliance program. And they were very, very worried that whenever they ask for these messages are not provided to them on the grounds that these are encrypted and these are in the private devices of an employee. And they said that we always need these messages for the purpose of review, audit, or investigations. Now, they went after the organization and they said that you review your policy and you modify your policy so that, and I want to see in your policy, where is the provision which says that you have a right to access these messages which are official communication in a personal device. Official communication in a personal device, how have you built in your policy to access these official messages in a personal device, and they call it bring your own device. That's the concept that they used. And they said, what is your policy that is saying? I want to see that policy. What is your policy which says that how will you discipline and penalize an employee who refuses to share the official messages exchanged in your personal device? So the regulator said that we want to see that. And they said that, look, we can't have access to these messages through these companies, Facebook, WhatsApp, Telegram, but at least I can reach out to the organization and I can push you.
Yeah.
I know for sure that there is an organization who started taking an undertaking from their employees, saying that if you are doing an official communication
On a personal
on your
device.
personal device, you shall provide that to the organization whenever sought after.
Right.
No, that is the changes that you have to keep doing in your policy, align your policy with the changes in the rules, regulations, notifications. That's the very, very important element of your compliance
No,
program. Yeah.
fair enough. I think that's a very, very crucial point what you've touched on, which is internal communication, communication on personal devices. What is the right of law enforcement agencies in seeking this information? And I'm going to ask Justice Zervos to give his view. What is what is the position in Hong Kong? How does that happen? Do you get access or do you allow access to encrypted messages or to email communication?
Well, it's got to be done pursuant to a specific power for a specific purpose. We have legislation that deals with this, but you can access that type of information. But if it's outside the ambit of the matter that's under investigation, it's got to be information that will further the interests of justice and is related to a matter under investigation, whether a regulatory or a
Yes.
criminal matter.
Right.
So there are, in Hong Kong, there are provisions that cover for that. But you can have a situation where information is accessed which can be completely outside the ambit of the inquiry being conducted by the regulator or the
Yes.
law enforcement agency, and that should not be looked at,
Right.
and that's protected.
That's lovely. Thank you. I'm now going to go back to Amar and then segue back to Justice Zervos. We are seeing companies now proactively conducting internal investigations, right? So we've right now been talking about how you deal with external bodies, right? Now it is something that we used to see in MNCs. I think largely European and American companies proactively conducting internal investigations. Okay, I want to understand from you your view on is this trend? Is it merely a trend or is it the need of the hour? Number one. Number two, how do you as a GC decide that, yes, there has now been a trigger for us to conduct such investigations? What is that kind of dividing line, or the trigger that you feel justifies or say, because it's a painful process, okay, it's very unpleasant, and it's a time-consuming process. You may have to involve external bodies. You may have to have independent, maybe third-party, maybe lawyers who are specialists in handling investigations, and you'll be creating a huge report at the end of this. Okay, and as you know, we were discussing, that's a double-edged sword. So, what is it that triggers? So, what is the need for it? Is it something that Indian companies are adopting today? Or is it still an MC concept? And third, what triggers? How do you handle that?
Good question, Charanya, and I'm not touching upon those whistleblower investigations and those harassment, harassment investigation and all. I'm just touching upon an internal investigations which is triggered because there is an external investigation going on.
Right.
It's very important that how do you investigate those issues internally, because you might do an internal investigation and you might generate some of the papers, some of the emails, which could be a subject matter of your external investigation. You might prepare a report, investigation report. You might see it from a different lens when you are doing this internal investigations to understand how justified that external investigation is. But that report can at times be self-defeating and self-damaging. So one has to be very, very careful, and that is where Mr. Prasanna is saying we have 5 minutes to
Sure,
go.
absolutely. We'll close.
We will finish, Mr. Prasanna.
Yes.
So it's very important that these internal investigations has to be done very tactfully, very discreetly, and the JC has a big role to decide what is to be investigated, what is to be looked into, how much document you need to generate, how much reports, emails you need to exchange. Another very important component here is if the issue is very sensitive, critical, damaging, I always advise involve forensic.
Right.
Many of these forensic investigations goes deep into it, and they are able to discover many things which we are unable to discover. Now the catch here is that these investigations will only forewarn you the direction in which the external investigation will go. Right. So therefore, it is very critical that how do you collaborate with forensic investigators, right? So this is very critical because they will have an access to all the emails.
Yes.
And they will do a lot of forensic investigation, and they might come out something which may be a published report or a formal report which may be self-damaging. So I say that's very tricky things.
Tricky thing. Okay, thank you. Now I'm going to ask Justice Zervos, and I think we'll conclude with this question, and then we'll probably just go around for concluding remarks with everyone. So an internal investigation has been conducted. Okay, certain people have been found to have committed an error of judgment, let us say, in taking certain decisions, but you find as a judge, when the matter comes to you, that it's otherwise a very compliant organization in terms of how, Vineet explained that there's a compliance policy, they have checklists, they're trying to do the right thing. They also have an internal investigation that has taken place. And this also is sort of presented to you as evidence, right? I know I'm putting you in a spot, but this is not a court, so it's fine. How do you look at, I'm looking at it more from trying to understand how you would look at this quality of evidence, which is that it's a compliant organization. They've also done their own investigation. And at the same time, a couple of people have been found to have...
Well,
yes.
It depends on what particular action is before you, whether it's civil or criminal.
Right.
But let me just say, look, this is a complicated issue, and it can be a two-edged sword.
Yes.
When you're carrying out an internal investigation, because you've got also an obligation to investigate to ensure there is compliance. And we're finding now with a lot of regulatory legislation where the obligation is on the company or its compliance officers to report suspicious transactions.
Right,
For instance, anti-money laundering. Yeah. And if you don't report, there's a criminal sanction against you.
Yes.
So you then become the eyes and ears of law enforcement because they can't find it and uncover it. So they're making you have that obligation. So it's one that you've got a legal obligation that you've got to meet, which could visit you with criminal sanctions. And at the same time, you can't overstep the mark to the point where you've undermined a criminal investigation. And you could have repercussions against you for that as well. So it's a judgment call. There's no straightforward answer.
Fair enough. Thank you. Thank you so much. I'm going to have,
I think my personal take would be there has to be a zero tolerance to illegal activities.
Right.
So I think better disclose, notify,
right,
ask the question to the regulator, etc. Follow that mode. That's a better way of going about than to be caught somewhere late.
So your last words are being for this session.
Yes.
Is that so be compliant, be proactive in reporting.
Yes.
Disclose wherever
Disclosure.
possible. Right. Yes. Amar, your comments.
My last comment would be cognizant of the changes that's happening in terms of the legal landscapes, the changing laws. the notifications, the judgments, those are coming up. India is undergoing a whole process of transformation as far as the legal matters, our legal landscape is concerned. A lot of new laws is coming up. So keep reviewing your policies, keep looking at these new changes that's happening, and make sure that your internal policies are in compliance with what is happening outside.
Perfect. Thank you. Thank you so much.